Turn your mic on.
Let's call the meeting to order, please. We'll have the clerk call the roll.
Counselor Hildenbrand,
Present.
Counselor Arnold,
Present.
Counselor Oropesa,
Here.
Counselor Corn. You have a quorum.
Thank you, clerk. Today we're having one action item on our agenda. It's a proposed ordinance to advertise, to hold a public hearing and consider adoption of proposed ordinance 2207, amending Chapter 27 of the Roswell City Code relating to cannabis. This meeting being duly published is in its proper format, is it not, Mr. Patterson?
Yes, sir.
Okay.
We do also have one other action item, which is approval of the minutes.
Pardon?
We do have one other action item, which is approval of the minutes.
Gotcha. Okay. Okay. So, do we hear any comments from Mr. Oppresso?
Mr. Chair, I move that we approve the agenda as presented and also approve the minutes of the March 24, 2002 Legal Committee.
I'll second.
All in favor? Aye. All opposed? There being no opposition, that item is approved. Patterson?
There we go. Good evening, Chair and counselors. I don't know how you would like to proceed, if you'd like to do a motion first and then hear the presentation, or the other way around, however you would like to do it.
However you want to proceed, Mr. Patterson, to make it clarity for everyone, because there's a lot of new members up here.
Typically, it's a motion and then a second and then presentation and then discussion.
Okay. So the action needs to be?
Yeah, a motion to...
I move to adopt, Mr. Chairman.
We have a motion?
Second.
No, do we have a motion?
What?
Councilor
Make a motion.
Corn made a motion.
And we have a second? All in favor?
Well, let's not vote yet. We're going to
Oh,
do the
wait for
presentation
discussion
first.
now.
Yes.
Ready? Now we're in for your, I thought we'd already done that, but I guess not. So let's move on.
Thank you. Okay. So we do have one item today. This is proposed ordinance 22-07. You will recall that this item originally came before the last regular city council meeting, placed on the agenda by the mayor, but that one was referred back to legal. This is a totally new document, different from the one that came previously. And so what I have tried to do is take in all of the different comments that were made at various times at the meeting and since then about what would like to be seen to be amended. And so I've tried to incorporate all of that into this. If any of that is not exactly what you meant, it won't hurt my feelings. If you want to say that's not what I meant, I want to change it like this, that's perfect. That's what I'm hoping for. Just to kind of recap where we're at. The council did adopt Article 27 of the Roswell City Code last August, and that basically set out the framework for regulating cannabis, and that was right after the time that the new legislation from the state, the Cannabis Regulation Act, was put into effect, and so the city then went to address that, how that was going to be rolled out for the city. The council then did two more amendments, 2110 and 2113 in October and December, which kind of fleshed out a lot of that, and then kind of set in place the procedure that we have today as it stands. In a really kind of, 10,000 foot view of it, for a new cannabis business that wants to come into the city, there's kind of four major steps that they do. They start with a pre-application review, and then that's filed with the planning department. And then they go before planning and zoning and request a consideration of a zone change and a conditional use permit. The zoning commission itself does not have authority, unlike in other cases, to unilaterally approve or disapprove itself. It recommends, and then that goes to council, which reserves the final authority to approve or disapprove the zone change and the conditional use permit. Once approved at that level, depending on where it's located, they may also bring a request for a variance or something like that. Once that's approved, then they come back to the planning department and request a regulatory permit, which kind of gets into like what your site plan looked like, what's your business plan, who are the operators of this business, and kind of gets into all those nitty-gritties. The security plan, for example, all that comes into the regulatory permit that follows the zone change and the conditional use permit. So the zone change itself is kind of a unique procedure, which we researching kind of what we wanted to do. We encountered this concept called the floating zone. Floating zone is unlike your typical zone, which it's on the map and it's there and you can look at it and here's the zone, right? It's red or it's yellow, R1. The floating zone floats in theory until an actual application comes forward, and then if it meets the requirements that of the law and is permissible in that location, then it lands on the site, right? Okay. So we have two ones, there's ICANN and CCAN. CCAN is permissible, I think it's in C2, basically commercial cannabis businesses, and then ICANN, if I'm recalling right, is in I2, and that's industrial, so that would cover other things like manufacturing as opposed to like retail sale. Now, the thing that mainly brings us here today is this issue of the non-conforming uses. So we did have a situation in which we had several businesses which were already set up at the time that the ordinance came into effect. And at that time, of course, they were only doing medicinal because that's what was legal at that time. And the issue became, how do we treat those businesses? After talking about it a whole lot, the decision of the council at that time was to treat them basically like other non-conforming uses. So the idea is that like you're a bakery and you're in C2, and then the council comes and they rezone it as residential. Technically, that bakery's not allowed there anymore, but we don't make them move because that's not really fair to them. And so we create them as a non-conforming use. But really, basically, what they are is they're kind of like trapped in amber, like frozen in time. They can never change what they're doing, and if they stop or change, then they have to go back and figure out how to comply with the zoning ordinance and with all of those codes. So that was the choice, to treat them in that manner, just like those. So it's not a special thing we created for the existing uses. We basically took that model and we copied and pasted all those restrictions that are in the zoning code into Chapter 27 and said, okay, you're a medicinal, but you're not, you don't have a floating zone and you don't have a conditional use. We're going to treat you as a non-conforming use. You're trapped in amber. And so that was the model that they adopted in the current Chapter 27. So then, notwithstanding that they got different permits from the state, for purposes of Chapter 27, they're trapped. So that's kind of the existing structure. So now we come to new chapter, or new ordinance 2207, which will be our fourth cannabis ordinance, our third amendment if adopted. Because the first one, of course, just set up the scheme, the framework. So I have a couple of different, I'm going to go section by section through the different proposals and explain to you kind of my thought process of why I did it that way. And then, when we're done, you can kind of come back and say why I like this or I don't like that. So the first thing we have is an amendment to the fees structure or ordinance section. So the first thing that was requested is that we put in the ordinance exactly where you can find the fee resolution. And we've done that, and now says, if you look at it there, that you can go onto the community development website and it will be posted there. So that gives notice to anybody. The next section provides what's a kind of a unique procedure that we don't do in other places. It's a notice provision, which would, when we propose to adopt new fees that relate to cannabis, we would send out a notice ahead of time, right? And just let them, hey, we're going to do this, FYI. And that gives them the opportunity to put input. Now, okay, let me say, first of all, my thought process here was hearing a lot of the feedback at the city council meeting was, how could we have brought the industry in on the front end a little better to have a smoother rollout, less surprises, and more input from the entities that are themselves regulated by this. And that was kind of one of the comments that I drew out of that discussion. And this is kind of a way going forward to be able to have a mechanism that requires that staff keep in mind that these people are out there and that they're affected by this. Now, this, like I said, this is unique. We do not do this for other industries, so it would be a unique situation. Here's my thought process on that. So normally when we issue fees, right, they're not industry specific. Like we'll issue a business license, but whether you're cannabis or a bakery or a bookshop, you pay the same fee, right? And so normally, in the vast majority of cases, there's not a unique group of people that are specially affected by a particular regulation. Cannabis, now I'm not saying we never do that, but it's rarer. Generally, our fees and our structures go across the board. You know, if you want to get a variance, there's one fee for variances, and whether you're an individual, a business, whoever you are, you want a variance, same price, right? But cannabis is not like that. We have a special resolution that plucks cannabis out of the market and treats them differently. Now, there's an important reason why we do that. You know, coming forward, this is a totally novel situation, and there's a lot of concern about sort of the how this is going to be rolled out and what are the implications of all of this. You know, and so that's where the idea was we're going to have zoning requirements, we're going to have conditional use permits, we're going to have regulatory permits, and all of these things are unique procedures with their unique fees that are built into it that apply really specially to cannabis. And those fees are based on the idea of cost recovery in the sense that because it requires so much staff time to review and make sure that this is a business that is in the right place and all of this, we're trying to make the city whole for that consideration. So that's kind of the back and forth is this is a unique procedure for a fairly unique set of regulations. Take that for what it is. That's the idea there. Okay, so the next proposal is that we add, there was a request to add a definition of vertically integrated cannabis establishment, the VICE permit, and this is just taken straight out of the state statute, and I've got the site there for it. Of course, we don't want to adopt any ordinances that would be different from or contradict state statute, and so the way, and I'll tell you that as we rolled this thing out, there was so much discussion about the definition section. You would not believe how much we argued about how to approach definitions, and so after kind of batting, do we put them all in there, copy and paste them out of the state statute, or do we, do what we ended up doing, which is to incorporate by reference all of those cannabis statute definitions, and then only separately define in our ordinance those particular definitions which were unique to our ordinance. That, and the benefit there is, of course, you cut way down on the amount of text in your ordinance. Also helps you make sure that you're never in conflict with state law, because whatever their definition is, it's our definition, right? So that's the procedure. However, I do understand that was my argument, and I ended up winning the day. But I do understand the comment that for non-lawyers, it's super annoying to be like, oh, go see that, right? It's over there. Go check something else. Lawyers love incorporating things by reference. It's our favorite. We incorporate everything by reference. But I get that lay people don't really like that as much. So I can understand the other side of it. Okay, the next thing that came out of the discussion was, can we generate some hours of operation for retail that apply citywide? And so we've got two proposals there. One would be in operating standards, we would add a new subsection K, which just sets forth that on Sunday through Thursday, 10 to 8, and 9 to 10 on Fridays and Saturdays. That was kind of an idea that was thrown out there. I will confess that I have no personal idea what the normal or good hours of operation are for cannabis establishments, so I am open to suggestions on that one. That was just my thought. And then same thing for those types of cannabis retail establishments that do eventually get permits for on-site consumption. The proposal here would be to limit those hours the same way, so that on-site consumption would also be cabined in by those hours of operation for retail sales. Okay, so now we get to kind of one of the bigger issues here, which is the non-conforming uses. I didn't quote you the whole section there because it's a whole lot of dense text with strike-throughs and underlines. I'm trying to give you the upshots here. So basically, the way that I thought about it was we're kind of shifting our model. So before we were treating them like those traditional non-conforming uses and they're trapped in amber. Now the feeling I got was a move towards treating these businesses as if they were already correctly zoned, right? So as if they were already a retail facility and they'd already gone through that process, and so basically they wouldn't have to get a zone change and they wouldn't need a conditional use permit. We're going to treat them as if they were already doing that, as if they'd already done that, and then they would just go straight to, we're going to get a regulatory permit. Now that doesn't mean that we have no ability to oversee them, because the regulatory permit, as I was mentioning a couple minutes ago, is actually fairly onerous. in the sense that you need to have a business plan and a site plan and show that you comply with all of the city codes with regard to, fire and all that stuff that you have to do. You have to have a security plan. You have to produce information about who are the owners of this company and, what is it? It's a LLC, it's a whatever it is. And so you do have to come to the city still with the regulatory permit, pay the fees associated with that, and then go through that process. But you would no longer have to get a zone change. You would just be wherever you are as an existing use, you're there, and we're going to treat you as if you were in the right zone. And the other aspect of that is that you wouldn't need a conditional use permit, which would drastically reduce the city's oversight in terms of what conditions we could put on the front end of that, right? So the way that the ordinance was built was that a lot of the regulation was going to be kind of specific to the entity. This kind of idea of appropriate for the neighborhood uses, right? And so as an application came forward, the Planning and Zoning Department would come to the Planning and Zoning Commission and say, we recommend X, Y, and Z conditions on this, right? So by eliminating the conditional use, you no longer have that process, okay? That's kind of one aspect of it. And then thinking about it, as I started to draft this thing, I suddenly realized that an issue that we could not ignore was this question of the on-site consumption, because one way or the other. And it's one of those things where, the ordinance is built, it's many, many sections, and they all kind of relate to each other. And so you change one thing over here, and it has implications over there. Mm-hmm. And this is one example of that. So as I was drafting, I was thinking, okay, we're going to treat you as is, as if you had been properly zoned, right? So a properly zoned entity could, assuming that it had the facilities to do it, could come to the Planning and Zoning Department and say, here's our plan, we've got a lounge area, and we've got all the stuff to comply with the Clean Indoor Air Act, and we've done all the great stuff. We want to do on-site consumption, and they would be able to apply for that, and if they met the requirements, they would be issued a permit for on-site consumption, right? So if we're treating them as if they were properly zoned, they would be able to do all the things that a regular retail establishment could do, including apply for an on-site consumption permit. So that was just my thinking about it, and here's what I would say. I'm not saying that this is the right way to do it, I'm just saying that this was the way that was consistent with the way that I was thinking about it, as we're treating them as if they were properly zoned. They can do all the things that a properly zoned entity could do. If you don't like that and want to go a different direction, I suggest that you choose a path. In other words, I think it's a bad idea to open the floodgates to this stuff and not address this issue, because under the existing ordinance, it's clear. If you are a non-conforming use, there's no way you could get on-site consumption, because you'd have to modify. It would be a change in your operations that would wipe out your status as a non-conforming use. But now we're saying, okay, these non-conforming uses can in fact do additional things. Well, what's the limit of that? That's immediately the question that comes to your mind. Where are we going to draw the line? So if the idea is we don't want these businesses to do on-site consumption for whatever reason, because we didn't get a chance to check that they were in the right place or something like that, do it the other way around. Say they will be able to apply for an operational permit, but shall not be eligible to apply for on-site consumption. That's what the nightmare scenario for me is we don't address that in the ordinance, and then here comes somebody, walks into planning and zoning as one of these non-conforming uses that are now able to do retail sales, and goes, boom, here's my application. And staff doesn't have anything in the ordinance that clarifies whether they can or they can't. So either way. The next thing that we did with regard to existing non-conforming uses was we took that section 152, which has the laundry list of all the things that you will do that will eliminate your non-conforming use status. In other words, require you to then comply with zoning. And as I said, this section 152 is actually copied and pasted from the zoning code. It's identical. So we're treating them, like I said, exactly the way we would another business under the same circumstances as we were thinking about that. But that said, there was some request that we could maybe make this less onerous on these businesses, that they could, that they were here, but we didn't want to trap them in amber anymore, right? And so one of the things about being a non-conforming use is you can't expand, you can't change, you can't do anything new without and then you'd have to go back and get all your zone change and your conditional use permit and everything that you would need to do if you tried to expand your business or move to something different. And so the idea was, well, maybe we can find a middle ground. This was my idea. We would allow them to do repairs and alterations, additions and enlargements, But if they discontinue their use, or they leave it vacant and similarly don't use it and don't do cannabis operations, or if they have to restore it to, and I forget the exact verbiage, but basically more than 50% of the value of the place, so a major restoration, then they would be considered to have lost their non-conforming status and have to go back to get a zone change, get all the stuff that they didn't have to get as a non-conforming use. Last piece here, this is a really easy one. Because operational permits actually themselves have in the ordinance that you are required to have your conditional use permit before you can apply for your operational permit. That doesn't work for non-conforming uses that are allowed to get an operational permit under this model, but don't have to get a conditional use permit. So it says, except in the case of a non-conforming use, which doesn't have to, everybody else has to have a conditional use permit from the city before they can apply for that operational permit. So those are really all of them that are in this ordinance. Like I said, I'm kind of interested to know what you all think, and I stand for any questions.
Actually, I do have a couple things I wanted to mention. I received some phone calls from some counselors. Some very fine points were made. From my professional relationship with law, I'm used to the definitions. When it was actually, kind of explained that the city here has kind of stuck to the rule of not actually adding them because then it has to be followed by staff and updated consistently, and it actually increases the workload. I am open to removing that if it is actually something that the entire council wants to look at as a problem, okay? Another issue was the actual fees going out in where we actually send out notice on those. Their concern again was the work overload for the staff, which I completely understand. But as I'm actually reviewing your updating them on any changes in the future to fees that have to do with anything regarding cannabis, not just zoning and ordinances or any requirements like that. So I actually did appreciate your verbiage in noting it elsewhere so people could actually find it. I will actually move on to, I gotta be able to see what I'm looking at, so hold on there. Okay. On the times, I thought actually you covered that really quite well, but I think myself personally would prefer the weekend time to be 9 to 9. 10 gets a little too close to midnight for me. So let me see. If I actually, here's where I'm going to need clarification. So I understand under the non-conforming users, you're actually saying that those basically, I like that analogy, lock them in amber. And I actually appreciated that being locked in amber, they wouldn't be able to make changes, because I do think that if they are planning to make changes, we need to actually review, because we definitely don't want them, extending or building a larger area that shouldn't be there. But where I think I was confused and still am confused is if they were already locked in amber, why are the vice users having to go through zoning?
They don't have to go through zoning to continue doing medical sales. That's the amber. They're frozen. They can only do those sales which they did at the time that the ordinance was enacted back in August. In August, the only thing that was legal was there was no recreational at that time. They were all doing medical marijuana. Mm-hmm. And so if they're locked in amber, they can only do what they did at that time. And that's why they're limited. The vice notwithstanding, because they were trying to go forward on the non-conforming use standard, they're locked into that one type of sales. If they want to expand and use their entire vice license, they can apply for the whole gamut with the zone change. And my understanding is that most of them have at this point.
Okay. That I think that, I just actually read an interesting clause from the state, and that, in my mind, would actually bring about several questions on that. So at this point, you're pretty much saying that you've removed them from the amber, and if they're allowed to do both, according to these.
If this were adopted, yes, the only thing they would need to do before they could move on would be to get that regulatory permit.
Right.
That would be the only last thing they would need to do to move on to the full sales. But yes, this would accomplish that, I believe.
Okay. All right. And then moving forward, once they've passed the regulatory sales, should they decide to expand their building or do anything of such, they still need to go through zoning?
No, that was the restrictions that we removed. So there's repairs and alterations, additions and enlargements right there. Those are being struck out of the restrictions. If we put those back in, then we would be where you're at, where they could do retail sales, but if they wanted to change either use in any way, you would want to put those two subsections back into the restrictions.
Yeah, I would actually like them back.
So what I would, if you would like to do that, make
Please
a
caution me.
motion to amend
Okay.
to reinsert those back into the section.
Okay. All right. All right, I wanted to go over some clarifications, and I
ma'am.
can try to figure out how to make the motions properly. Can you actually move forward to the no operational permit? Oh, go back, I'm sorry, to the operational permit.
The operational permit, that was right at the end.
You were actually there, and I spoke too quickly. Okay, so let's go break this down a little bit more here. Except in cases of non-conforming uses, a conditional use permit from the city as required by this chapter. Can you kind of
Right.
re-explain what you were?
Sure, yes. Okay,
Thank you.
so remember that the two elements that we are removing from the requirements for non-conforming uses are a zone change
Mhm.
and a conditional use permit,
Mhm.
right? Because if you'll let me go all the way back, up there. So those are the four stages.
Right. Mhm.
They could jump straight to regulatory permit, right? They wouldn't have to do any of those three things, the first three things. They wouldn't need the zone change. They wouldn't need the conditional use permit, right? They would be required to do that regulatory permit. So this is the actual section that says you have to get a regulatory permit before you can begin operations. For a new business that is not a non-conforming use, before they can apply for this operational permit, they have to do all those things first. So this says one of the factors you have to have before you can complete your operational permit is you have to have that CUP.
Mm-hmm.
But if we're going to say that non-conforming uses don't need a CUP, but they can get a regulatory permit, then we have to mention that over here, except for a non-conforming use which does not require one, you must have one.
Okay.
Yeah.
Thank you. And I think my biggest concern was I want them to be able, and I feel this is actually what the state was kind of putting out there, is that they should be open, but at the same time, I do want them to have time limits. I think that we want to establish hours of operation, which I think you did a fabulous job of doing here. And also, I do want to make sure that if they decide to become a weed supermart, we have the ability to limit that. So, sorry, thank you for smiling at that. That was my joke. But anyway, that's all I have at this time.
Thank you, Mr. Chair. I just need clarification, since we're having a special city council meeting right after this one. This is to take it to a reading, right?
Yes, well, you can recommend it or not, or recommend it with changes, but it's already on the agenda for the special.
Okay,
So,
but the meeting that we're going to have right after this one is going to be to determine whether we take it to reading or not.
authorized to advertise, so there will be a public hearing at the plan is, and I should have explained the timeline, that was my fault. So the idea is that we're going to, legal will make some recommendations about any changes that you want right now, and then we'll have a special, and at the special city council, of course, I will then say legal has recommended this and this and this, and then they will authorize to advertise at that special, And then that gives 2 weeks time period, which is required by statute to hold a public hearing on 2207 at the regular.
Okay, just wanted to make sure that
Yes, sir.
it was understood. The other one that I wanted to clear is a vacancy. On the next to the last slide that you had,
Yes. Yeah.
on the remaining limitations, it's got vacancy, and I know it kind of defined vacancy, but is this vacancy regardless of whether it's control of the owner or not?
It does not matter the cause of the vacancy, as I recall. It's just if it's vacant, you lose it.
Okay, so regardless of whether, I don't know, he got sick or she got sick or whatever, as long as it's been vacant for 6 months, then they would have to go through the whole process all over again?
Yes, they would need to go and get their zoning and everything if they, regardless of the reason why, left it vacant for 6 months. That's my understanding.
And the next thing that I want to address, and I don't know whether it's a proper time to address it or not, but I'm gonna put it out there and then you can tell me, is the 6% excise tax that we talked about at the council for rehab services.
As I recall, that there was not any particular stipulation on the use of it. That was my recollection, but I have not had a chance to verify that 100%. But my recollection is just like GRT is what I recall.
Because
We
at
could,
the
we as
last meeting, I brought up the fact that we needed to look at rehab services for some of the individuals that may, get affected negatively.
Counselor, I think,
And I don't know who came up with and said that there was a 6% excise tax already included in the regulation.
yes, I don't remember if it's 6%, but there's a cannabis, like basically gross receipts tax specifically for cannabis that's higher than the regular one, and then some of that is shunted off to the local jurisdictions, and some of it is kept by the state. And I don't know operationally whether that's just going to come sort of in with the regular GRT or whether they're going to separate that out. I don't know, but assuming that we're able to identify which part of it comes from specifically cannabis, I don't see why I don't think there's any problem with the council saying we direct that this money be used for this purpose, right? The council
But this
does
would-
that from time to time. But
There would have to be something taken above and beyond what we have right now on the table.
Yes, well, you'd have to amend the ordinance at that, and there is a chapter called taxation there, but it's blank right now. It's one of those ones that hasn't been filled in. So if you wanted to, you could put in there something that says in an amendment, all cannabis, assuming, again, I don't know operationally how it will come in, but assuming that we're able to identify what is cannabis GRT, we could direct, the city council could adopt an ordinance directing that those funds be expended on such and such a function, such as, addressing the negative effects socially of this cannabis consumption in the city limits.
But that can be done at a later date.
Yes, sir. I don't think that this is going to be the last cannabis amendment that we're going to see, frankly.
Because I think that is very important.
Yes, sir. No, I understand.
And whether everybody else agrees with me or not is up to them, but
What? No,
I would like to see something that identifies that we are going to provide some type of rehab for individuals that get into trouble.
Counselor, and I did hear you last time. This one was just such a quick amendment. We did not have time to build that, which would be like a whole new section. It's not just modifying existing ones, but yes, that is on my radar. We're looking at that, and I want to bring it to the, as soon as I can to this forum here.
Okay, thank you, Mr. Chair.
Councilor Corn, any comment? I think we're fine there, Mr. Patterson.
Okay.
But I do have one question
Yes, sir.
about on-site.
Yes.
What did the original cannabis ordinance address on-site?
There is a section in the existing code, and it's not been changed, which says you have to get a permit, and it's subject to the review of the city manager or his designee, which is going to probably be planning and zoning. And so they have the ability at the front end to set in place, well, you need to have these conditions. There's not a specific set right now, except that it says that in reviewing the permit application, the city will set reasonable standards. One of the things that's actually in the statute is that they can't be within the school limit, so we set it at 300 feet. So, for example, if you've got an existing cannabis facility, you can't really seek a variance, I don't think, from that one, because in the state statute it says that an on-site consumption area cannot be within the limitation period, or area. So if you've got one right now that's within 300 feet of a school, they would not be eligible, for example, to apply for that permit, notwithstanding they would be able to engage presumably in retail sales because they wouldn't need a variance.
Right, so this amending does not alter what the original was?
No,
Because
no,
that's not the intent of what this was to do, was to alter any of that.
No, nothing about on-site consumption. There's like I said, there's a section, about at least one section addressing it. We have not touched that. This just says those retail facilities that are non-conforming uses that can now sell retail, if they're otherwise eligible, can similarly apply for this permit like any other retail business. But it didn't affect the actual provisions of that section relating to those.
Okay.
Yeah.
Thank you. Any other counselors have any comment?
I don't know, is this the time when I actually need to make the motions?
Yes.
Okay, so I'm gonna need help with the verbiage on this. I'm gonna make a motion to amend or strike from the amendment repairs and alterations, additions and enlargements. How would you like me to phrase that appropriately?
There are currently, the proposal is to strike them too, so I make a motion to reinsert them.
To reinsert, okay, to
Yeah.
reinsert them. Okay, I would like to make a motion to reinsert repairs and alterations under section 27-152 restrictions and include additions and enlargement in that as well.
Do I have a second? Second being, all in favor?
Aye.
Aye. All opposed? There being no nays, so adopted.
Okay, so at this time, you can, another counselor, or you could make another motion to amend it, something else, or if there's no more motions to amend, you can move to, it's on the floor, the motion to adopt, and so, or not to adopt, to recommend, to advertise, so you could just vote on that if there's no additional other motions to amend or do anything else with it.
I have an additional motion to amend. I'd like to amend under definitions to go ahead and remove the definition for vice. But thank you for inserting it.
Do I have a second?
Second.
All in favor?
Aye.
All opposed? There being none, so moved. Okay. Public discussion can we have now?
Yeah, absolutely.
I want to ask, because we have special council meeting at 5, that anyone who wants to come up for public discussion, so be it, but try to limit yourself to be considerate of the 5 o'clock time limit we have. Anyone wishing to participate in public discussion? Please come forward.
Hi, my name is Will Boston. Good to see you guys again. Very well done, by the way. I was just going to clear something out about the vice license itself. So just because the vice license by the state has the opportunity to have the whole spectrum of different, manufacturing, production, retail, potentially a consumption lounge, each place is licensed individually. For example, our location where we are now is licensed as a retail location. To do a consumption lounge at the location we're at requires a state approval for that consumption lounge. So just because we're licensed there, doesn't mean that we can go in the back end and say, okay, we're gonna start a consumption lounge now. And that's not our intent anyway. I agree with the council and everybody else. I think consumption lounges are bad. And the state says there's never to be on-site smoking. So if you're a retail spot, it's strictly prohibited to smoke on site. That's all I want to say.
Thank you. Mr. Patterson, just one clear correction. On on-site usage, you said, does that eventually go to council for approval, or that is a staff approval process?
As I recall, currently it's a permit at the staff level. I don't think that those go to council as it's currently drafted.
Thank you. There being no other business,
Chair, I actually would like to make one more motion. I would like to make a motion to amend the weekend times of operation to close at 9 p.m.
there being a motion made, do we have a second on closing the weekend operations to 9 o'clock from 10?
I'll second it.
There being a second, all in favor by saying aye. Aye. All opposed? There being no opposition, so moved. Any further discussion? Please move to the podium, please.
Hi, thank you. I really appreciate the comment.
Would you please state your name and address? I'm sorry.
I'm sorry, my name's Kim Rutley. I live at 2006 Clover Lane.
Thank you.
I appreciate the clarification about the on-site consumption. I was involved in the passage of the Roswell Clean Indoor Act in 2004. So again, smoke is smoke, so we have a secondhand smoke issue there when you have on-site consumption. So that being very important. But one thing that I don't know if it's included in this part of the ordinance or how we handle it, but public education through signage is really, really helpful. And I don't know if that's, again, something that would come in here, that businesses should have some kind of signage on front, businesses where you can't use, so the public knows where you can and can't use. Is super important. I was just in TRC this weekend, very small community. Everyone's converted to recreational, and it's pretty much the whole talk and mood of the town. And I was given a flyer by someone, and that led me to a home where there were, like, mason jars of every type of cannabis you could think of, and they said their kids help with the business. And so I just want you to know that it's and infractions at the district. I was just informed by the official here that they've doubled in our schools since April. Twice as many kids bringing THC to school. So it's really impacting the community, so the more education we can do, more signage, whatever, we would love to help with that and have funds for that as well at La Casa. Thanks.
Thank you. I'll give my own personal interjection there on that just for a second. That I know that we passed this cannabis ordinance back in December. What we're trying to accomplish today is advance the medical, and I don't disagree with you that there are some additions that need to be asked and answered as this moves forward. I am personally, and I don't like to interject myself personally, but I believe in public education of what's going on here and what our commitment from this council to the citizens of this community are on education of usage. And I would also think that, listening to Councilor Represa, that we need to address some other issues that were probably not addressed back in December. And so this will be not the last time that we will be discussing our cannabis ordinance. So, anyone else have comment? Please step forward, state your name and address.
Hello, my name is Andrew Hertel, 610 West 2nd. I just wanted to say I work for SWAP, and it seems like a lot of the disagreements with the ordinances come from just misinformation. And I'd like to personally invite you guys to come check out one of our stores sometime, so you can see the security measures, the measures that we take to make sure that we're selling in a responsible manner. Additionally, sorry, I took notes for a reason. I just wanted to say, you know, when it comes to the new licenses, they're going to be producing cannabis. There's three main places for that cannabis to go. The vice licenses like us, the new retail licenses, and then anything that's left over unable to be sold, unfortunately, is the black market, and that's a lot of what these issues are coming from. And, you know, unfortunately, it is the will of the people to have these sales. The most responsible hands are our own. Thank you very much.
Yeah, I'd like to visit your place, but I don't have a medical card, so I can't go in. That's not my rule, that's the state rule. So, is there anyone virtual that wants to comment? Do we have anybody on virtual? There being none, any further business? Meeting adjourned.
Mr. Chairman,
Oh, nope.
little housekeeping.
We still have to vote on the actual motion on the floor, which
Wait
is
a
to,
minute, we got to back up even further than that. Who made the motion? Okay, then I need to amend my motion to include adoption of the ordinance as amended.
Yep.
And hopefully my second will follow.
Second.
Favor?
Aye.
Aye. Any opposed? There being none opposed, so approved. Now we can adjourn the meeting, and so we can have another meeting.
yes, sir.